Distinguished guests, colleagues, ladies and gentlemen, it's my pleasure to welcome you to the Banco Court for the final Selden lecture of 2022. We're meeting on land that by tradition is in the custody of the Turrbal and Yagara people, and I express my respect for their elders past, present and emerging. Tonight's lecture is about a person who in some ways was a controversial figure, but there are many things about Sir Frederick Jordan, I suppose like most of us, that might be thought interesting and admirable. I think, for instance, the fact that at 17 he started work as a clerk in the Master of Lunacy's office is interesting. One of his associates was Jack Slattery, who was later Chief Judge in Common Law in New South Wales, and he recalled, for instance, that Sir Frederick preferred to catch a tram to work each morning, and in the afternoon he would catch the tram away from home to the terminus, the opposite direction, to ensure that he would have a seat for his journey home. He's reputed to have been a slightly interventionist judge. He's reported as having said to a very earnest King's Counsel, who persisted in an argument after being told that it was unnecessary, "Mr. X, the court has already informed you that we are with you, subject, of course, to anything you may say to cause us to change our opinion." But according to according to Sir Maurice Byers, when he appeared in front of the court on which Sir Frederick sat as a member, he listened to my bad points with admirable patience and with patent disbelief. Our speaker tonight is Keith Mason. Keith graduated from the University of Sydney in Arts and Law. Much later, he would be awarded an honorary doctorate of laws by the university. He was admitted as a solicitor in 1970 and to the New South Wales Bar in 1972. He took silk as Queen's Counsel in 1981. He served for 2 periods as chairman of the New South Wales Law Reform Commission. And from 1987 to 1997, he was Solicitor General of New South Wales, succeeding Mary Gaudron in that role on her appointment to the High Court. He became President of the Court of Appeal of New South Wales in 1997, serving in that role until 2008. For today's purposes, importantly, he is the author of Sir Frederick Jordan, Fire Under Frost, that's published by the Federation Press. Would you join me in welcoming Keith Mason?
Thank you, Judge. It was the late Dr. John Bennett who encouraged me to write the biography of Sir Frederick Jordan, who was Chief Justice of New South Wales between 1934 and 1949. Bennett had written histories of that state's Supreme Court and legal profession. He also authored biographies of 18 Australian Chief Justices. "Freddie Jordan is the most interesting of them all," he told me, regretting that his own lifespan would not reach to crossing that Jordan. How fortunate for me. This amateur historian was ushered into the rapidly expanding world of judicial biographies, a wonderful way of exploring law and society in context. Bennett had penned a note on Jordan in the Australian Dictionary of Biography, and he provided me with several leads. In contrast to his research burrowings, I was able to plug into Trove, which since 2009 has delivered online access to all Australian newspapers of the early 20th century. Thank you, Selden Society, for this invitation. I would encourage you to keep promoting the exploration of modern Australian legal history. Jordan was the 9th Chief Justice of New South Wales. He would die in office, as 5 of his judicial colleagues had done, most of whom left trails of unfinished business. He was a brilliant linguist, a bibliophile, and a lifelong educationalist. Shy in company and austere in the courtroom, his nickname was Frigidaire Freddy, said to give his wife a cold every time he got into bed. He held strong views on the rule of law, the corruptibility of police officers, and the degeneracy of modern art. He wrote judgments of remarkable clarity and style. Some of them are expressed in very forceful language. Standing here in 2022, Jordan has, in my estimation, the claim to be the most influential judge yet to have served in an Australian court, with the exception of my namesake, Sir Anthony Mason. I do not overlook the stellar Owen Dixon, but his star has faded a little over time, and my selected criterion is influence. I shall return to Jordan's continuing impact on the law in this country, and I'll offer a few comparisons between the lives of the 2 near contemporaries, Dixon and Jordan. One thing can be said at the outset. Jordan respected his judicial colleagues and had a much happier time on the bench than Dixon. Happier too than any Queensland Chief Justice of the 20th century that I know of. Perhaps he was fortunate not to have been born into a judicial dynasty. Let me discuss 5 of Jordan's legacies. First, the provision Jordan made for his widow, Bertha. He was born in London in 1881, the only child of parents who migrated to Australia when he was 5. His father opened a produce store in the then working-class suburb of Balmain. Frederick lived in the family home until he was 46, by which time he had acquired an immense practice at the Sydney Bar. He met and married his wife Bertha on a shipboard venture in 1928. She was in her mid-30s. There were no children. When Jordan died in 1949, the bulk of his estate passed to Bertha under a will that had been executed on their wedding day, after the nuptials, as the law then required, handwritten by Frederick, hopefully not on the day of the wedding, but there it is. The widow was left with the palatial home they'd built in Vaucluse, 7 Balmain properties derived from the senior Jordans, and another dozen in that suburb bought during Fred's lifetime, and 3 others elsewhere. The widows of judges got no pension in those days, but Bertha was very well provided for. Whenever she went on one of her many trips to Europe, she would sell off 1 or 2 of the houses. It took me some time to track down the family members of this childless couple. I constructed a rough family tree from snippets of information and sent it off to people whose names seemed to fit. One putative grandniece emailed a quick reply. "You are wrong to presume that my mother has died. She would like to see you as soon as possible." I would meet a delightful old lady, Varro Legg, now deceased. She started by telling me about her PhD and how climate change was a hoax. She was Bertha's niece and her residual beneficiary. After I showed her my draft chapter about all the Balmain houses, she observed ruefully that most of them had been sold by the time Bertha died and left her estate to her. But she pointed out a grandfather clock that had come out from London with the Jordan family in 1886. Jordan's next major bequest was an extensive law library. Much of it can be found today in the High Court Library because Jordan left it to Dudley Williams, his junior of choice. It was Williams who took up the High Court appointment that Chief Justice Jordan turned down in 1940. Evatt had announced that he was leaving that court to return to politics. Latham, the Chief Justice, was on his way to Tokyo in a fruitless attempt to stave off the war in the Pacific. Owen Dixon contacted his former pupil, Prime Minister Robert Menzies, who promptly agreed that the position would be offered to Jordan if only he could be persuaded to accept it. Dixon's diary entries that are set out on page 43 of my book tell the story in detail. Dixon himself was anxious to get away, possibly for good, from warring judicial colleagues on the High Court, whom he considered lazy, mediocre, or in Hayden Stark's case, plain horrid. Dixon was bored and oppressed by the grind of writing and ghostwriting judgments. He wanted to do his own bit for the war effort. But he was anxious to leave the High Court in the care of someone he admired, both as an advocate and as a judge. Jordan was simply not interested in joining the squabbling Federal Appellate Court. The best he would do later on that front was to assist his own pupil master, Sir George Rich, by ghostwriting one or two of his judgments. My third legacy of interest is Jordan's vast library of books outside the law that fell into his residual estate to be auctioned off at Dimmicks. The nominal value assigned to them in the death duty affidavit did not reflect their value to Jordan, let alone the market. Books were Jordan's lifeblood. He collected and borrowed them in enormous volume. He read voraciously, travelling on the ferry to Sydney High School, on the tram from Vaucluse to and from the city, and out from the city and back, as we've already heard, after dinner at home, because he didn't bring any judicial work home, and in his dedicated railway carriage as he travelled to circuit sittings. In 1945-46, Jordan was doing double duty as acting governor of the state. There was an extended standoff between Premier McKell and the Palace over McKell's refusal to accept a Brit as Governor of New South Wales, even a member of the royal family. The chapter in the book tells of some of the machinations that the previous governors were doing behind the scene to try and force McKell to change his mind. And as I say, one of the Queen Mother's Bowes-Lyons family were even offered, and McKell said he's not suitable. One of Jordan's unhappy duties in his gubernatorial role was to attend Randwick Racecourse. No lover of sports of any kind, he sat perched high in the viceregal box reading a French novel, even as the horses thundered past. Jordan had taken honours degrees in Latin and French before proceeding to the Faculty of Law at Sydney University. He was enrolled throughout as a part-time student because his family could not afford the fees. Entering the state public service, he worked first in the Master in Lunacy's office, then the Tourist Bureau, then the State Library. At the library, he would encounter a circle of literary and artistic friends that included the dissolute poet Christopher Brennan, the quixotic Albert Piddington, the Lindsay brothers, Norman and Lionel, and the eccentric parliamentary librarian J.J. Quinn. He kept up these bohemian connections after he went to the bar in 1907. The men participated in luncheon clubs in which all conversation had to be in French. One of the clubs was called Les Compliqués. This name was chosen by Brennan as an allusion to a French novel in which, quote, a writer seeking a quiet place to work goes to a brothel and asks for a negress, hoping she will not speak, and a table. The madam replies, "Ah, you are complicated." Tu es compliqué. The dinner clubs petered out by the early 1930s, but Jordan's associations remained. The ideas these men shared would inform the liberal social attitudes and the passionate commitment to free speech that became hallmarks of his jurisprudence. Lionel Lindsay, the art critic, shared books and exchanged letters with Jordan until his death. The letters now repose at Jordan's old workplace, the Public Library of New South Wales, and they proved a wonderful resource in researching Jordan's life outside the law. I don't imagine that Murray Gleeson or Susan Kiefel will leave behind anything half as revealing and fascinating. It's difficult to convey in a lecture the extent and depth of Jordan's reading. It was jaw-dropping, even allowing for an era before television and a home without children. The book of essays called Appreciations, that I shall mention shortly, reveals close awareness of the complete works of writers of novels, plays, poetry, non-fictional works and literary criticism. Jordan was fluent in Greek, Latin, French, Italian and German, and he acquired a working knowledge of Spanish. He always preferred to read the original languages. There was an occasion in 1941 when he bought and read 4 of Dostoevsky's works in German translation rather than English, simply because it was a better translation. Indirect consequences of this life of books were Jordan's pellucid writing style and his judgments, which are strewn with literary allusions, and sometimes very obscure ones. But there was another, more direct output. Jordan shared some private essays about his readings with Lionel Lindsay, who persuaded him to publish them after judicial retirement. Alas, retirement did not come for Jordan, but after his death in office, Lindsay arranged their publication in an exquisite book called Appreciations. There's a companion book called Parallels that collects passages across literature on various themes. So, for example, on horse racing, he has quotes from about 4 or 5 different books, different languages, different styles, but conveying some common message that piqued his fancy. These extracurricular writings reveal much about the man beyond his eclectic literary tastes. In Appreciations, there are pieces on topics as dispersed as humour and magic, with illustrations from French, English, Italian and Latin. There's discussion of religion, children's books, detective works, ecclesiastical novels. Russian and German folk tales are analysed and contrasted. We're left in no doubt about the favoured and unfavoured writers. Jordan detested Thackeray, Joyce, Rousseau and Goethe, but he was familiar with all of their works. Appreciations offers extended glimpses of his views on philosophy, definitely no top-down reasoning from him, legal precedent, the sociology of religion, modern art, popular culture, and old-school ties. The opening essay about the cinematograph excoriated this popular obsession of Jordan's era, revealing Olympian attitudes that would today be branded as quite elitist. Jordan considered and described movies as, quote, exercising perhaps the most debasing of all influences on modern civilization, with deplorable results to standards of modern taste. The late Sir Maurice Byers offered this vignette about the public persona of Jordan. He was a tall, broad-shouldered man who wore rimless glasses and usually a brown suit. His expression was remote and unsmiling. His moustache was grey and close-clipped, his face pale and oblong, his forehead high. His eyes were distant, as if he was engaged in the solution of a particularly abstruse problem of quantum mechanics. He moved with an air of icy authority. The bar was firmly convinced that he had no human passions. But he certainly did. Maurice Byers sometimes regaled listeners after dinner with the assertion that Jordan, quote, owned an unrivalled collection of pornography. My friend and colleague John Bryson has observed that Unfortunately, I heard buyers say the same thing about Sir Samuel Griffith, which rather takes the guilt off the story. Although in logic both could be true, and rivalling a collection of pornography is not an easy concept. The very reserved Sir Frederick Jordan is unlikely to have boasted about any such collection. I suspect too that gossipy lawyers may have considered that collecting and devouring books in French and Italian established a prima facie case. Jordan was certainly able to discuss the topic of pornography in the writings of Proust and D.H. Lawrence. Of the latter, he wrote to Lindsay that, "I have no objection to pornography as such if it is well done, but Lady Chatterley's Lover, when it is not merely dirty, is cheaply vulgar, both in style and context. Not good, honest vulgarity, but the vulgarity of an inferior mind. If Lawrence ever had any standards, he must have lost them when he wrote it." My fourth Jordan legacy is his enduring endowment to legal education in Australia, quite apart from the corpus of his judgments. In Jordan's law graduating year, 1907, the only student to get a better degree and the university medal was Edward Thin, if that's the correct pronunciation, Reel, whose father, Patrick Reel, was a fractious judge of the Supreme Court of Queensland. In 1933, Reel and Jordan were briefed in a Commonwealth land tax case in Brisbane before their old lecturer, Mr Justice Rich, on the High Court. Reel told a journalist that Jordan's second-class honours degree reflected the fact that he was a part-time student. Jordan's dean, the redoubtable Professor Pitt Cobbett, had a very high opinion of this student. While at the junior bar, Jordan taught for about 15 years as the Chalice lecturer, expounding equity, bankruptcy, company law, estate administration, divorce and admiralty. Neither Queensland nor Western Australia had a law school at this time. In the upshot, over half of all lawyers graduating in this country in those years passed through his tutelage. Many of them would become teachers at the Sydney Law School before moving to the top of the profession. Jordan produced printed lecture notes to encourage students to listen rather than write. These passed down the generations, and new editions were published by Jordan or an editor working under his direction. The famous Chapters in Equity underwent 6 editions between 1921 and 1945. There were 3 other sets: the administration of the estate of deceased persons, general principles of the administration of justice, and admiralty jurisdiction in New South Wales. All of them were republished in 1983 as Sir Frederick Jordan Select Legal Papers, edited by admirer Roderick Pitt Marr. The first edition of Marr, Gummow and Lehane's Equity Doctrines and Remedies, published in 1975, drew extensively on chapters in equity. Like Jordan, it trumpeted an anti-fusionist gospel that had been rejected by Sir Samuel Griffith and is once again happily fading. Unlike Jordan, Marr, Gummow and Lehane's book became known for outbursts of incivility. Jordan's Chapters in Equity used to be cited by counsel and appellate judges until well into the 20th century. Not only was it authoritative, it was unique, given that textbooks offering Australian cases and addressing Australian statutes were unheard of before the 1970s. Jordan's final and greatest legacy consists of his judgments, 540 of them found in volumes 34 to 49 of the New South Wales State Reports, now accessible through Austlii. The series ceased in 1972, but in 2007 the Council of Law Reporting published an indexed. The Council's main reason was to make it easier to find relevant judgments of Jordan on obscure questions of principle, and there are many. Jordan's years as Chief Justice were fulfilling, and he presided over a happy ship. His 8 judicial colleagues were able and loyal. Latterly, there were the disruptions of the war years and the turnover caused by the frequent deaths in office, to which I've already mentioned. There were also the pressures of the year when Jordan doubled as acting governor. I don't know what the situation is in Queensland, but recent Chief Justices of New South Wales, when they've acted as governor, have ceased to sit in criminal matters for the reason that the Queen against meant that their representative, the Queen, couldn't sit. Now, for my part, I think that is quaint. It doesn't preclude judges sitting in civil cases, but it's a long tradition. Jordan didn't do that. He did the full burden of work while he acted as governor for 14 months. His health began to fail, but his judicial output did not. As Chief Justice, Jordan did both common law, civil and criminal trials and circuits. He presided over the famous Shah Khan murder case. The story that he concluded a sentence of death in another murder case by awarding costs in favour of the estate was entirely apocryphal. It may have started very early as a joke, pointing to the fact that as a barrister, Jordan had done very little common law work. But his main judicial work on the Supreme Court was in the full court, attending to civil and criminal appeals, judicial review and professional discipline matters. Almost invariably, he wrote for the whole court. His crisp outline of the facts would be reproduced verbatim when the judgments were reported in the state reports. Turning to the law, the reasons were didactic, reading like a mini lecture. Some, quote, general principles, unquote, would be set out in language that was compact and clear and before it was applied to the instant case. English and local authority would be cited but seldom discussed. No cut and paste extracts from other cases. Some legal history if relevant. The reasons for doctrines and practices were expounded. There could be gentle codas clarifying where Jordan differed from a colleague's judgment, not that there were many dissents from or by Jordan. With statutory cases, there might be a proposal for reform. Bad professional conduct would be called out firmly. None of the ethereal qualities of a Dixon judgment. During the Second World War, Jordan's court cut swathes into poorly drafted regulations designed in Canberra to meet wartime exigencies and curtail common law procedural rights. Garfield Barwick's star as an advocate rose rapidly in that context. There was one spectacular brawl with the executive, represented in the state by Premier McKell and in Canberra by Attorney General Evatt. Just after the bombing of Pearl Harbor, McKell closed all of Sydney's brothels, nightclubs and sly grog shops. He invoked a federal national security regulation that allowed him to make any provision deemed necessary to protect the person or property of the civil population in case of emergency. Jordan's court struck down the Premier's order as ultra vires. The nightclubs reopened with great fanfare. At the urging of the Allied war chiefs, a new federal regulation was promulgated, this time flagging the importance of protecting the morale and discipline of the armed forces stationed in Sydney. When a second legal challenge was launched, McKell trumpeted in Parliament that the nightclubs were cesspools of vice and used for subversive purposes by enemy agents, as well they may have been. The government lawyers would be treated to a public thrashing as the Premier's second closing order was also struck down. According to Jordan, the Premier could not, quote, give himself additional powers by his own vain imagining. The statutory injunction to preserve the morale of the civil population was no more than, quote, a windy generality which may mean anything and everything. Jordan acknowledged McKell's cesspools of vice argument, but considered this to be just as much a problem before the war. Parliament alone should address the issue, which is what then happened. In my view, this episode showed a somewhat unworldly side of Jordan, but it certainly demonstrated his independent, libertarian values and his intellectual domination of the court. After the war, in Browning's case, Jordan would declare that it was no business of the Water Irrigation Commission to allocate water licences in a way that favoured returned soldiers or discriminated against Italian-born Australians. This decision would be overturned on appeal in a judgment that Chief Justice Spiegelman has described as perhaps the low point of High Court jurisprudence. It has some wonderful phrases, Browning's case, but if you look at what actually was decided, it wouldn't be decided that way today. I'll say no more than that. Returning to Jordan's judicial reasoning, sometimes the Chief Justice would point out errors in the English or High Court cases. He did not ignore rank when it was pulled, but he never bowed to any notion of the bindingness of seriously considered obiter dicta. He also understood that reasons given by justices when refusing special leave to appeal were not binding. In the 2011 Western Export Services Special Leave remonstrance against resort to context in construing contracts, 3 judges of the High Court turned a blind eye to this. But in 2015, shortly after the departure of Justices Gummow and Hayden, the entire High Court would affirm Jordan's stance in the Mount Bruce case. I do not presume to speak for the Queensland profession or judiciary as to their practices when confronted with a precedent coming from anywhere south of the border, but I do know that a passage from Jordan about some corner of private law or procedure was all that a junior barrister needed in Sydney in the 1970s. Apart from the intrusion of federal wartime regulations, Jordan wrote before the age of statutes. His judgments in contract, tort, criminal law, equity, restitution and procedure are still highly pertinent. Many of them remain the primary citation on key principles. I would instance Small's case on subpoenas and the will of Gilbert on appellate restraint in reviewing discretionary decisions. Indeed, Jordan judgments are still regularly discussed and applied in the High Court, much more frequently than any single state or federal judge of the 20th century. Here I would instance 21st century applications by the High Court of Jordan distillations on sentencing, fixtures, essential and non-essential terms in contract, severance of invalid terms in contracts, the defence of fair comment in defamation, and lawful justification in the tort of inducing breach of contract. For chapter and verse, please buy the book. Pages 249 to 51. Justice Gageler has particular respect for Jordan, evidenced, among other things, by his analysis in Mann and Patterson, the restitution case which was decided after the Jordan biography went to press. In 2013, Gageler had been prepared to follow Jordan's wartime decision in Curry's case, which found a federal implication against mandatory minimum sentences. But in this, Jordan and Gageler were each lone dissenters. A brief word about Jordan's criminal law jurisprudence. Many of his rulings on criminal law and procedure remain canonical. His 1935 decision in Bales and Parmenter that the common law precludes police arresting a suspect for the purpose of questioning remains a beacon of civil rights to this day. It was endorsed by the High Court in 1986. Jordan pressed further with a campaign against the admissibility of police verbals in custody, seeking to have such confessional evidence treated as involuntary per se. But in this endeavour, Jordan's colleagues on the full court and the High Court parted company in McDermott's case. And in the specific outcome of that case, Jordan alone detected a miscarriage of justice flowing from the police evidence about very damning admissions made in custody. His dissent at least saw McDermott's death sentence commuted to life imprisonment. In 2004, long after McDermott's death, the remains of the murder victim were discovered in a place that put a complete lie to the police verbals. A relative's petition for posthumous pardon was referred to the Court of Criminal Appeal in 2013, and the conviction was quashed on the basis that the court was satisfied as to McDermott's innocence. Jordan's many contributions to the laws of contempt and defamation have been recognised in the House of Lords as well as the High Court. In Ex parte bread manufacturers, he ruled it is not a contempt to publish an article on a matter of public interest merely because a defamation writ was issued on behalf of the plaintiff. This ended the era of what used to be called gag writs. In his famous judgment about fair comment in defamation, Gardner and John Fairfax, he would declare that a critic is entitled to dip his pen in gall for the purpose of legitimate criticism. No one need be mealy-mouthed in denouncing what he regards as twaddle, daub or discord. There were many other felicitous and memorable phrases in Jordan judgments. Once again, you have to buy the book. You'll by now have detected that this biographer thinks very highly about the enduring influence of this outstanding jurist. There must be a species of bias that affects biographers. In my partial defence, I invoke personal experience with Jordan's jurisprudence as a barrister, teacher and appellate judge. What makes a judge great in one era may be unappreciated in another. For Chief Justices, the criteria of greatness are also contestable. Intellectual leadership, capacity to promote or resist change, communication skills with the wider public, getting it right in a landmark case. One thing is certain, for historians at least: appointment to an apex court can never be the hallmark. As Dixon himself said, it was a tragedy for the High Court that neither Leo Cusson nor Frederick Jordan were appointed to it. Dixon made this comment on his retirement in 1964. Whether Dixon would have stayed on the High Court that long, or at all, had Jordan joined in 1940, and what would have happened if Jordan had joined Dixon on that court, are interesting hypotheticals. I wish to close with two matters. First, some brief comparisons between Jordan and Dixon, and second, a comparison between the life of a Supreme Court Chief Justice in Jordan's era and the present. Jordan worked prodigiously and effectively, but his working day finished at 5:15. He'd get on the tram, go home, start reading his books, go home and keep reading his books. Dixon toiled into the night writing judgments. If you see his sad diaries, it just shows what an unhappy life he had on the bench. He read comparatively little outside of the law until after he retired. His jurisprudence was abstract and analytical. Jordan's was rooted in the practicalities of things and more consciously educative. Jordan enjoyed reading about the fallibilities of humanity, whereas Dixon was more often annoyed by them. Dixon devoted some of his prodigious talents publishing speeches and papers about judicial method, professional competence, and matters historical and constitutional. Jordan presented no public lectures or papers, with only the tiniest of exceptions. He wrote a letter to the Law Quarterly Review on one tiny point. Jesting Pilot, the collection of Dixon's brilliant papers, reveals little of the author's personality. The essays in Jordan's appreciations were crafted solely for his private satisfaction, and yet they are replete with self-revelations. What are the differences between the life of a Supreme Court Chief Justice then and now? Jordan's was the largest Supreme Court in this country, but he oversaw only 8 other judges and a couple of acting judges. In that era, the common law of England set most of the rules. Most trials were before juries. Appeals were not by way of rehearing. Sentencing was mandatory for capital crimes and totally uncomplicated for all of the rest. Commercial cases were not about thousands of documents stored on a CD. Reported decisions were few and unreported ones ignored. It would have been a meaningless insult to have suggested that any judge of the 1930s or 40s should attend to his continuing education, or to cultural or gender-based awareness, or to issues of bullying by or of judges, or to educating the public or the profession. Media interviews by judges were unheard of. There was no Council of Chief Justices or Judicial Commission or Law Reform Commission, nor any books to launch or conferences to speak at. The working life of a modern Chief Justice is much more complicated. Thank you.
Keith Mason, thank you very much for your presentation this afternoon. I feel I know about 500 times as much about Sir Frederick Jordan that I knew before. And for someone who sat, I suppose, on the same bench as him, but about at least 2 generations removed, you have, through the work you've done producing this book and, of course, tonight's paper, gained such an understanding of not just the jurisprudence, but the life and the personality of that judge, that I feel very privileged to have been present when you delivered it. Can I thank you very much for the work that has gone into your research and for the presentation here today, and of course for travelling here to be with us in person to deliver the lecture. Thank you. I'll ask you all to join with me in thanking Keith Mason. And would you accept this small token of our appreciation?
Thank you very much. Thank you.
Now, there'll be an opportunity for some drinks and refreshments outside in the portrait gallery if you have time to remain with us for a short period. As I mentioned, this is the last of the Selden lectures for this year, but we look forward to presenting another series in 2023. So I hope many of you will join us for that. Thank you.